Okay, good evening, everybody. I see there are about 50 of us at the moment. So let me have a quick look. Yeah, 47. So I think we're going to start, and I have started recording. So you'll see that I'm still sharing the the Word version of the PowerPoint presentation, which is effectively a summary of chapter 4 of the textbook. And what you will also notice as we discuss the content of chapter 4, that a lot of it is also discussed in chapter 5. So there is a lot of repetition, and we don't need to then spend too much time on that. For example, let me bring to your attention what I'm referring to specifically. This current topic that we're about to start with, which is holding the executive accountable. This section of chapter 4 explains in detail the fact that a president can indeed be removed from power, and it explains the two ways in which this is possible, being either in terms of section 89 or in terms of section 102. And all of that information is then dealt with again in chapter 5, because chapter 5 looks specifically at how our national executive is created or established, and the fact that the president is head of the national executive. And that's why chapter 5 shows not only how the president is appointed, but equally how he can be removed from office. And that shows us again that we in South Africa have what I would regard as a decolonized form of the separation of powers doctrine, because we have sufficient interrelationship between the legislature and the executive to make sure that the ambitions and aspirations of the drafters of our Constitution are in fact realized. So hopefully we can finish chapter 4 quite quickly this evening, and then next week we can deal with chapter 5, which is not a very long chapter. So we have already, at numerous moments in the preceding lectures, dealt with those important and recent cases that have fundamentally or significantly enhanced our understanding of how the Constitution is supposed to work, especially in relation to holding the executive accountable. And I think there's still some students who are not aware of the fact that tutorial letter 102 is where these recent cases can be found, and where I have tried to provide as much of the actual verbatim text of the judgment as possible, but without overwhelming you, and then provided a summary at the end so that you can hopefully discern what the relevance of the case is. But the reason why I've given you so much of each case is because every law student across the country seems to have a resistance to reading case law. And I understand it. It is very difficult and, intimidating when you are asked to read a case, especially one from our constitutional court. So that's why I've given you, I think 7 or 8 different cases to read, so that you get used to the way in which judgments are written. Hopefully, you also can discern from that a type of structure. And the courts don't always follow this approach, but a type of structure that makes it easy to understand what is actually being said and why. And the structure I'm referring to is FIRAC. And I think you know this from first year. It might have been referred to as IRAC in first year, but I'm going to say it again for your benefit so that you are aware that when reading case law, you should at first see that the court will inevitably first deal with some of the pertinent facts to contextualize the issue and explain why this case is in court. After the facts, it is when the court then starts explaining what the actual issue in the case is. So, is this a matter about a declaration of invalidity of the conduct of the president, or is it a case of a declaration of invalidity of the way in which legislation was passed, for example? Then the third part is where the court tries to set out as clearly as possible the relevant law that is applicable. So that's where the R comes from. And you could also use that R as the rule of law because we have a precedent system. And then comes the most important part, is the actual application, where you see how the court takes the facts they are presented with, applies it to the relevant law, and reaches a compelling conclusion. So that's why we call it FIRAC. And I'm saying this because in the UDM case and the economic freedom fighters cases of 2016 and 2018, you see the courts starting by saying these cases deal with the issue of President Zuma, and in the EFF cases, with the finding by the public protector that he was unduly enriched, and therefore a motion of no confidence was requested of the National Assembly in the first instance. And then the UDM case will refer to the EFF case because it is actually an extension of the same case, because it deals with the same facts, but just deals with a slightly different angle, because it talks about the fact that the United Democratic Movement had asked the Constitutional Court to make a decision obliging the Speaker of the National Assembly to actually exercise her discretion and the power vested in her to make the vote on a motion of no confidence a secret ballot. So that's what I'm wanting you to do, is get used to reading cases. And I'm asking you this because at other institutions of higher learning, very often in an assignment or an exam, the students themselves are asked to write a judgment where they are given a certain amount of facts, and they then have to, based on those facts and their knowledge of binding case law, be able to determine the relevant issue, the relevant law, and then partake of that most important process of actually coherently and persuasively applying the law to the facts to reach a conclusion and be able to say, therefore, this court finds that the president violated his oath of office, for example. So these cases that I keep mentioning, they are so important because they've transformed not only the way we understand constitutional law, but they are important also because they've been written in a more user-friendly manner than many other cases that you will have to read. For example, for family law or law of property, you might have to read very complicated cases that refer to Roman Dutch principles and to case law that's very old. Whereas in these cases, you see that the court is dealing with relevant current issues and is trying to advance the best possible interpretation of our Constitution. And therefore, the National Assembly, to bring us back to Chapter 4, is constitutionally bound to hold the executive accountable, and when it fails to do so, like we saw in the economic freedom fighters' cases, the court can, and in fact must, have the power to declare that the National Assembly or Parliament, which was created by us as the people, was not given due effect and implemented as it should have been. So that is really the essence of the idea of holding the executive accountable, is that we actually have a scenario where we have the judiciary having the obligation to make sure that the legislature holds the executive accountable. And that's why we see a close relationship between our judiciary, our legislature, our executive. They are not completely divorced from each other and have no role to play in overseeing how each other functions. So that I keep referring to it as a decolonized approach. That's my own interpretation. I would like to think that you agree with me, and I say that that's a decolonized approach, mostly because of my readings of the work of Bantu Stephen Biko and how he talks about the fact that at all times, Black consciousness was foundationally premised on holding the system, meaning the apartheid system, to account and trying to therefore eradicate it through the use of appropriate mechanisms, including the law. And when we saw, and I have to bring this up now because it is so pertinent in light of June the 16th, but as Bantu Stephen Biko said, there comes a time where the people have to take matters in hand and do what is necessary to change what is not working. Now, he most certainly did not anticipate, and I'm also therefore arguing that he did not incite the June 16th of 1976 student uprising, but he did demand accountability. Unfortunately, though, we had at the time a police force that was far too trigger happy. And in fact, Bantu Stephen Biko uses that term himself, that the police were far too eager to resort to violence in order to quell any Black resistance. And that is why we now see in our Constitution so much emphasis on accountability and of ensuring that we never regress to a situation that we had, where we had an apartheid government that had absolutely no regard for the rule of law, absolutely no regard for fundamental human rights such as dignity, equality, freedom, bodily integrity. And so we have a National Assembly at the moment in which we vest all of our faith, and we hope that the National Assembly will be able to keep those who are in power accountable, because we saw that the efforts of the South African Student Organization and the Black Consciousness Movement were most certainly a precursor to the way in which our Constitution was drafted. But of course, it came at such a devastating loss and expense, in that so many Black South Africans were tortured and killed or detained for years on end, and there was no way of turning that situation around while the apartheid government and the system was still at play. So this is why I keep going on about accountability, and why I mention it so often, is because I can't let you forget that the very word accountability is contained in Section 1D of our Constitution, informing us that we all must be accountable for our behavior. So we must take responsibility for our behavior, and we have elected representatives to sit in Parliament and speak and act on our behalf, to hold the government accountable if it is failing us, as the economic freedom fighters argued in the 2016 and 2018 cases, where they said the National Assembly have let the people down because they did not hold Jacob Zuma accountable for the gross undue benefit. It was millions, hundreds of thousands of rands. It was probably millions, but I think the eventual conclusion was that it was a few 100,000 rand that he had to repay. So you're noticing obviously a political discussion taking place, but I've said this before, constitutional law is, without doubt, the most political of branches of the law. You cannot separate law and politics. And that's then why we have a constitution that specifically says that our parliament has the power to call members of the executive to come before it and to account publicly for the way in which they are exercising their mandate and for how they are ensuring effective service delivery. So this is the wording that is commonly used, as that this reflects a culture which we're trying to establish of transparency, responsiveness, answerability, so that we can actually have confidence in our government. I'm saying that a lot of what I'm saying now also based on yesterday's Youth Day webinar and roundtable discussion organized by the UNISA Law Clinic. And I'm not sure how many of you attended that, and I didn't attend the whole day, but I could see from the comments that so many students, yourselves, are feeling let down by our government. The government is not doing enough to actually ensure that there's responsiveness and answerability about youth unemployment, about corruption, and about, for example, the education system that is failing the large majority of our youth, who are now feeling desperate because you are sitting at a university, you either a NSFAS beneficiary, but you know you have to pay back the money at some stage, or you are spending your own money or your parents' money and you're trying your best to obtain a degree so that you can actually alleviate your own and your family's poverty, for example, and make a success of your life. And yet the government is not doing enough to ensure employment opportunities for people like yourselves. And I don't even know what your ages are. Some of you might already be employed, but this is a societal problem, and none of us can sit back and say, it doesn't affect me, so I'm not going to engage in the discussion. And that's why, as I said last week, the National Assembly has such strong powers in holding the executive accountable that the very word summons is used. Summons meaning calling a particular person, I'm just making sure that everything's still okay, yes, calling a particular minister to come and account. And I think in this regard, the Minister of Education does need to account more often about what prospects there are for students who are finishing their degrees but who feel hopeless because they know that they are not likely to obtain meaningful employment or employment in the field in which they have qualified. So the idea is that our National Assembly, speaking on our behalf, must be able, and then they in fact do have the power, to call the relevant minister and the president, if they need to, and say to them, explain to us where the failings are. Why is your department not doing enough to ensure that there are available employment opportunities after the student graduates with a degree? And so it then, of course, relates to the second point on the page, which is that accountability is only meaningful if it actually entails that someone is properly held accountable and where proper remedial action can be taken. So proper remedial action, we've seen, for example, we've discussed this before, where the former Minister of Social Welfare, Batabile Dlamini, was forced to make a large payment to the various non-governmental organizations that had to bring the case against her because she was derelict in her duties when the South African Social Security Agency had entered into an invalid contract with a service provider. And she, as minister, who was ultimately responsible, was told, you need to find a new service provider so that the social welfare grants can be paid on time. And she did not do it. And we reached a stage in or about April 2016, I think it was, where everyone who relies on a social welfare grant to survive was unsure whether or not they would actually receive their grant. And so the minister was brought before Parliament to account, and she was equally, as I've just said, brought before court to account. And so, as you notice in that heading, the powers of the national legislature even extend to dismissing members of the executive if they fail to account properly. And it's exactly the same mechanism as you see with the removal of the president. It is an impeachment. So it is a resounding statement that the person has violated their oath of office because they undertook, when becoming a minister, to uphold the Constitution, uphold the law, and do everything in their power to make sure that their portfolio is a success. So in the identical fashion that the president is removed, a minister can be removed from office as long as 66.6% of the National Assembly vote in favor of that person's removal. And as you know, we have never seen that before. It's never resorted to an impeachment of a minister. What we've seen instead is cabinet reshuffles. But very often, even those cabinet reshuffles are questionable because some ministers who we think have failed in their duties have been reappointed, sometimes in a different portfolio, but they remain a minister. So it does leave us questioning the disjuncture between the theory in our Constitution and the reality. So the third, well, this whole discussion about Section 102 of the Constitution is also identical to how the president can be removed in an alternative fashion, and it applies then equally to ministers, where a minister could be recalled by the party, and that's really what happens when there's a cabinet reshuffle. It's the same idea, but we've had this discussion last week, where because we are a political-based parliamentary system, so a political party-based parliamentary system, we do see that in most cases, the governing party will quietly shuffle the cabinet or recall a minister and remove them and substitute them with someone else, instead of subjecting that minister to the indignity and the embarrassment and the consequent financial harm of having them removed through a motion of no confidence because the political party itself has lost faith in that minister. So this process of removing the president applies equally to removing ministers, because we have a system in place where our ministers and, of course, the president are at all times supposed to work for the benefit of us, the people. So the Mazibuko case that I'm sure we've mentioned repeatedly, but for those who might have forgotten, the importance of the Mazibuko versus Sisulu case is that this was the very first time ever in South Africa's democratic history that any motion of no confidence was brought against the sitting president. And it was brought by Lindiwe Mazibuko, who was representing the Democratic Alliance at the time, which was an opposition party, and it was Max Sisulu, who was the Speaker of the National Assembly at the time. And so when Lindiwe Mazibuko formally tabled the motion of no confidence, Max Sisulu stated that the rules of the National Assembly do not allow an opposition minority political party to bring a motion of no confidence. And of course, that makes no real sense, because why do we have a proportional representation system in our parliament if the minority or opposition parties actually don't count? And that's why the case ended up in the Constitutional Court, and the court then said, these rules that currently exist in our National Assembly, which give the Speaker enough or too much power to actually completely disregard a request for a motion of no confidence simply because it's brought by a minority party, is invalid and unconstitutional, and therefore the rules must be changed to allow any other political party to bring a motion of no confidence, because in the words of former Deputy Chief Justice Moseneke, a motion of no confidence is indispensable to our democracy, because without it, the head of the executive and the ministers, I'm just inferring that, will be able to act with absolute impunity. So he said, as Moseneke then continued to say, a motion of this kind is the most important mechanism that may be employed by Parliament to hold the executive to account, and, to my mind, more importantly, to interrogate executive performance, because we too easily just accept bad service delivery or violations of the Constitution because we believe so strongly in majority party dominance, that if the African National Congress is the liberation party that was the strongest, and of course that's also debatable, but the strongest in bringing an end to apartheid, then we let certain things slide because we are so grateful to the ANC and we feel so loyal to the ANC that we allow certain grievous actions to take place with impunity. So the idea, therefore, of course, is that if there's going to be a motion of no confidence brought by any political party, it has to be tabled, and it has to be tabled as a matter of priority. So even if other issues are supposed to be debated by the National Assembly, if it's a motion of no confidence, our court says, then that debate must be prompt, and therefore the Speaker must take reasonable steps to ensure that the motion is dealt with without undue delay. So, of course, there's a discussion we actually had last week, and that is when President Mbeki was recalled, and we had this discussion about is a recalling of a president actually constitutional? Well, it's not a regular change of government or alternation of political power, but because our Constitution doesn't expressly prohibit it, and no one has ever come to court saying it should be invalid, it has happened on more than one occasion, as we know, and it has happened in such a manner where the sitting president has resigned instead of being subjected to a motion of no confidence. So you see, therefore, that the political party takes the initiative of approaching that president and saying, you do realize that the alternatives you have here are not very good. You either resign or you are going to be subjected to a motion of no confidence, which not only means that you yourself lose power and lose all benefits of office, but the entire cabinet also has to resign, and that is going to impede the proper administration of the state. So similar to accountability is this idea of oversight. And oversight is something that is dealt with in much more depth in chapter 8 of the textbook. But oversight literally means that the National Assembly must be aware of what is happening in each portfolio on a day-to-day basis. So they can't, for months on end, just let one of the portfolios operate under the radar. No one knows what they're doing and they don't really worry. They think everything's absolutely fine. What the National Assembly is obliged to do is consistently oversee all actions by organs of state, particularly when it comes to service delivery, and therefore maintaining the oversight to improve service delivery and achieve what our Constitution sets out, which is the obtaining of a better quality of life for all citizens. And of course, oversight, therefore, also includes ensuring that legislation is implemented properly. So I know I used this example last week about how our refugee legislation is not being implemented properly. And that is merely one example where insufficient oversight and accountability is taking place, and the refugee legislation is not being implemented as it should. But that is most certainly not the only legislation that's not being implemented effectively. Otherwise, we would not be seeing the violent service delivery protests that we are seeing every single day in this country. And so generally, oversight can take the form of either members of the National Assembly doing what the legal term is an in loco inspection. So you might have heard that term maybe in criminal law, where members of the National Assembly can actually go themselves to a place and see what is happening for themselves. I think one example, I don't know if it's possibly a little bit too contentious, but what we do see is the economic freedom fighters going, the leadership and those members who are actual members of the National Assembly, of the economic freedom fighters, going to various schools, and I'm using schools because that's been the biggest issue of late, and making it known that they are there to find out what's going on, so that whatever the problem is, it can be rectified. But the issue then is, because it's only members of one political party, there might be allegations that it's not entirely an independent oversight process. But the idea is that a number of members of the National Assembly should be going to the places where there are issues to conduct this fact-finding operation, to show that they are hardworking and that they are actually committed to ensuring that their obligations as members of the National Assembly are being complied with. And so what's important then is that the way in which the National Assembly operates is most often through committees. So the Standing Committee on Public Accounts, or the Committee on Justice, Security, and I think Correctional Services. I think it's all now joined together because Home Affairs has also been brought under that umbrella. So all of those committees are there to investigate what is going on and to make recommendations so that the situation can be improved, with the ultimate aim being enhancement of the actual implementation of the policies and the laws, and if necessary, placing an institution under administration so that a proper investigation can take place. And I'm mentioning that in this lecture now because there have been I don't want to use allegations, let me not say, there have been requests by some student bodies, for example, to put UNISA under administration so that proper investigations can happen about what has happened to the NSFAS funding or how the Vice Chancellor was appointed. All of that is a perfectly constitutional and protected request, because that's what the National Assembly is supposed to do. So the Minister of Higher Education is empowered, if he sees fit, to place any institution of higher education. Fort Hare has been placed under administration. Walter Sisulu University has been placed under administration. So it's not an unprecedented event, but institutions of higher learning, I would say especially one as large as UNISA, possibly needs to be put under administration to see that the students are receiving the service delivery that they anticipated when they registered at that institution. And maybe there needs to be a restructuring or a reorganization of the institution to make it work more effectively. So I'm using these examples not to sort of promote any kind of autonomous action on your part, but just to use them as examples. So then, even though I've now explained at length that our National Assembly has very far-reaching powers, at the same time, there are constitutional limits placed on the National Assembly. And of course, the most prominent is that at all times, the National Assembly must remain open, transparent, and must involve the public in decision-making so that every decision it makes can be defended and justified because it was made in an open and transparent manner. And even though the National Assembly is seen as being this body that must operate strictly in terms of the Constitution, and that therefore the members of the National Assembly must at all times, for example, respect the dignity, let me say, of other members of Parliament. One of the limits on the National Assembly is that when it comes to debates in the National Assembly, members of the National Assembly have certain rights or privileges, is the better expression, so they can say whatever they think is necessary, even if, as we've seen in the Delil case, for example, what is said is seen to be an insult or somehow ostensibly harms the integrity or dignity of another political party or a politician themselves. That is the very essence of ensuring that our National Assembly actually can operate to the best of its ability, if the members can speak freely and openly and not be constrained by any threats of being arrested or charged civilly or criminally for saying what they think they need to say, so that there is unanimity amongst everyone in Parliament as to what the real state of affairs might be. And of course, we know, lastly, that the most important limit, and I call it an obligation of the National Assembly, is to ensure that the National Assembly facilitates public involvement. Otherwise, we know that their decisions can be declared null and void and of absolutely no consequence. All right, so at the beginning of the discussion about the structure of the National Assembly, I showed you the diagram that we have two houses of parliament in South Africa. We have the National Assembly, which is the dominant and therefore bigger House of Parliament. But we have a second house. The second house, which is slightly smaller, is called the National Council of Provinces. And you will realize that the National Council of Provinces operates in an identical fashion to how the National Assembly operates. For example, it must be open and accountable. It must ensure that the public participate effectively in the passing of any legislation that comes before it. And it must be able to create rules for how it will function. And those rules can be declared invalid if they are not actually consistent with how the Constitution envisages the National Council of Provinces to function. So we have a National Council of Provinces that is established in terms of a specific Act of Parliament called the Mandating Procedures of Provinces Act. And it is that act that says we shall create a House of Parliament to ensure that each of the 9 provinces of South Africa have a close enough relationship with central government. And that's why the National Council of Provinces works very closely with the National Assembly, because the National Assembly is the quintessential central governance of the state as far as the legislative arm is concerned. And we know that if the National Assembly can then appoint the national or head of the national executive, then equally the National Council of Provinces must be able to be involved and to know about those decisions so that that information can be filtered back to each of the 9 provinces. And so I have told you before that after each election, the National Assembly is reconstituted anew, and we therefore call it the first, second, third, fourth, fifth, even the 6th Assembly. That is not the way that the National Council of Provinces operates, though. The National Council of Provinces is never, ever supposed to be dissolved, because the principle is that it is a body with perpetual existence, and it has a fixed term, meaning for the entire duration of the state having 9 separate provinces, we will have a National Council of Provinces that is there to ensure respect for the rights and the involvement of each of these provinces in central governance, because we know that our system of cooperative government, remember chapter 3 of the Constitution says South Africa, and this is where I take you back to that diagram from our very first lecture, that we have a legislature and executive and a judiciary, not just in the national sphere, but also in the provincial sphere, and likewise at the local sphere. So it's the National Council of Provinces that is that perpetual link between the national sphere and the local sphere. And so when we talk about oversight and supervision, for example, what we are referring to is how the provinces have a fundamental role in monitoring, overseeing, and supervising how the local spheres of government are operating, because that is where service delivery actually takes place. And because the provinces are in the middle, we have the National Assembly monitoring the provinces and the provinces monitoring the local sphere. So there is supposed to be this interdependence, indivisibility, communication between the three spheres of government to make sure that our constitution really does work as envisaged. So the composition now of our NCOP is, of course, slightly different from the composition of the National Assembly. So I know I've said this umpteen times, but just briefly, we know how the National Assembly is composed because we know that after every national election, the members of the political parties whose names are mentioned on the lists take their seats on the basis of the proportion of votes that each political party obtained. Similarly, each province has its own provincial legislature, which is also composed in exactly the same way, where we have the Gauteng provincial legislature, which might have a dominance of the African National Congress, so that there'll be more members of the African National Congress. Then there'll be a few less members of the Economic Freedom Fighters and a few less members of the Democratic Alliance, for example, or the IFP, based on the proportion of votes received. So each of these provincial legislatures operate within their specific geographical areas, but each of those 9 distinct legislatures need to send a delegation from their provincial legislature to the separate house called the National Council of Provinces. And that is therefore how the National Council of Provinces is composed. So because we have 9 provinces, it makes sense that the NCOP is composed of 90 persons. So each provincial delegation is composed of 10 members. And those 10 members are also, of course, based on the proportional system in place. That's how the 10 are selected. But there are then 2 categories of the 10 members. So that of the 10 members, 6 of them will be called permanent delegates. And those permanent delegates are usually chosen because they have specialized or particular knowledge of certain issues. And that's why they will go to the National Council of Provinces to represent the Northern Cape provincial legislature, for example, at a particular time when the law on, for example, artisanal mining is to be discussed. And we know that there are diamond mines in the Northern Cape. So that's why someone who has specific and specialized knowledge on mining, for example, will be one of the members of the permanent delegation, because those permanent delegation members can be changed from time to time, as long as the total number being 10, remains the same. And of the 10, it's 6 that can be changed from time to time, depending, as I say, on any specialized knowledge. So there's those 6 who can be substituted with someone else, or it could be the same person throughout the tenure of the National Council of Provinces after an election. It just depends on the province itself. So the province has quite a lot of discretion. But then there's a separate category, and those are the special delegates. And so, as the name implies, special delegates have to include, most importantly, the premier of the province, because that's why the person is the premier. They were elected to ultimately take accountability for the entire province and make sure that all the laws and policies of the central government and that are passed by the provincial legislature of their province are given effect to. So there will be, of course, the premier, and then any 3 other persons who are specifically chosen as special delegates. And those special delegates then remain members of the provincial legislature. So that is an important point, because that's how we ensure that there's proper communication between the National Council of Provinces and the individual provincial legislature, is because those 3 members are simultaneously members of the provincial legislature and members of the National Council of Provinces. So they have to keep reporting back and saying, to be tabled in 2 weeks' time is the draft bill on expropriation of land without compensation. Therefore, can we please, this is hypothetically speaking, but can we please make sure that of the 6 permanent delegates that we know can be changed from time to time, can we make sure that at least 2 of the 6 are experts on property rights or on the right to tenure, protection of tenure in respect of communal land, like the Ngonyama Trust, which is the Zulu portion of communal land where predominantly Zulu people live and sustain their livelihoods. So because we are concerned, for example, that this expropriation of land without compensation might impact on communal land, we need someone who actually knows something about communal land and who can make a statement on behalf of this provincial legislature, stating that communal land must be separated and therefore not fall within this new proposed law on expropriation of land without compensation. And so that we've seen happening in practice. And that's why the late king of the Zulus, he was one of those who said unambiguously, and the African National Congress then had to acquiesce or agree. The former king said, or the late king said, whatever you decide about land, you must not deal with communal land. It must be separated, because we deal with our communal land in terms of customary law, so you need to stay away from it. And that was how that sort of conversation happened. So there is this, well, what I'm trying to convey, I suppose, is there must at all times be open, transparent communication. And that's why we have a National Council of Provinces to represent each of the 9 provinces in a close relationship with the National Assembly, so that what the National Assembly decides doesn't happen in isolation from the interests of the provinces. And that brings us then to our discussion of the functions of the National Council of Provinces. And so I've mentioned this in various ways before, but the critical role of the National Council of Provinces is to provide a voice for the opinions of the provinces, especially when it comes to legislation that is going to have a fundamental impact on the economic or social or cultural or any other interests of that province. So I use the word region here, that's from the textbook, but province is the best terminology. Because if laws are passed by the National Assembly without any involvement of the provinces, it may very well turn out that that law is not workable for the province. So the National Council of Provinces must be able to communicate its views and its interests to the National Assembly, so that those views are legitimately taken into account when the National Assembly is drafting laws. And so it is ensuring that the provinces, who are actually also then speaking on behalf of the people at the local sphere, their interests are genuinely taken into account. So I've discussed the Doctors for Life case repeatedly, but the Doctors for Life case is a seminal case as far as proper a proper relationship of participation and respect takes place between the people and these legislative fora. So in the Doctors for Life case, the court said, our National Council of Provinces reflects a fundamental premise of our government, because we have a national, a provincial, and a local government. But these 3 spheres don't operate in isolation. That's why the diagram shows overlap between them and arrows showing interrelationship and communication. So as I've actually already said, but it can't be emphasized enough, that even though the national, the provincial, and the local spheres are distinctive, interdependent, they are still interrelated, and they must be responsive to each other. So they must be able to account to each other for how they are managing their affairs, so that there isn't any incoherence between a national law and a provincial law that actually then are unconstitutional, because the two are clashing and causing a vacuum of power, or a vacuum in terms of service delivery. So there must at all times be a responsiveness to the needs of the people generally. And this is how the needs of the people at the provinces and also at the local sphere are genuinely taken into account. So here where I state that our National Council of Provinces has wide-ranging powers, you will actually realize that it is almost a verbatim copy of what I just said about how far-reaching the powers of our National Assembly are, because of the fact that the National Council of Provinces equally has the power to summon anyone to appear before them, including the president and cabinet ministers. And those persons summoned to appear before them must swear under oath that they will tell the truth. They must provide any documentation that is requested. They must be able to report or account to the National Council of Provinces about what those ministers have actually been doing to make sure that the interests of the provinces are genuinely being taken into account. And of course, they must be able to receive petitions from people, because we know that lobbying by interest groups is one of the best ways of making the National Council of Provinces aware if the people in that particular province have an issue and want rectification of the issue. So you will have probably, maybe you've signed one yourself, but petitions which say, we the hereby undersigned demand that the minister makes sure that there is sufficient health care being provided in the province of Gauteng, and it might have 10,000 signatures. That petition must be able to be given to the National Council of Provinces so that the National Council of Provinces can consider it as a whole and say, this petition that's been lodged with us, saying that the Gauteng province needs to do more, for example, to provide vaccines against COVID, is actually not only relevant for Gauteng. Therefore, we are going to ask the Minister of Health at the national level to come and account to us about how vaccine rollout is happening in all 9 provinces. So that's where we as the people can communicate directly with members of the National Council of Provinces, because they are the gateway to the National Assembly. They can make the National Assembly account for things that are going wrong. Then, of course, specific powers of the National Council of Provinces, as it is implied that it varies depending on the impact of the legislation in question, because some legislation might not affect one province at all for any particular reason. It is determined entirely by the subject matter of the legislation. So the National Council of Provinces has an important role in making sure that it fully comprehends what the impact of the particular legislation is going to be on all provinces or on certain provinces. And that becomes relevant then a little bit later on, you'll see, with how the National Council of Provinces then tags a bill. Because the more that particular law impacts on the provinces, obviously means that the more power the provinces, through the National Council of Provinces, must have in making submissions about the nature and content of that proposed legislation. Very importantly, is that all 90 members of the National Council of Provinces have an individual vote. So it really is an empowering institution, because everyone there has a vote, one man, one vote, which is the epitome of democracy. And so the general consensus is, if it's ordinary legislation that's passed, that's going to have an impact on the provinces, everyone must have a vote. The only difference, though, is when it comes to specific laws that are going to amend the Constitution, such as the current bill on expropriation of land without compensation, then each province has only one vote, because it's that entire delegation that has to speak with one voice. And that's why the word mandate is used. And that shows then that the role of the dominant political party in that province carries enormous weight, because that's when, if the African National Congress, who is committed to expropriation of land without compensation, they will say to their delegation, you will vote in favor of this bill. Whereas in another province that might be dominated by the EFF, which has a different view, they will say you will vote against the bill because we do not approve of this bill in its current format. So you see then that the party does have a very strong hold over the decision-making of the NCOP. So just like I've said previously about oversight, it is identical to how the National Assembly conducts oversight, in that the National Council of Provinces has the power to review the intervention of the national executive in a province or in a municipality. Now, that is of extreme importance, because we've seen, for example, where the Tshwane Metropolitan Municipality was placed under administration and, in fact, was dissolved, for example, the National Council of Provinces cannot just sit back and say, oh, it only affects Tshwane and it's only part of Gauteng, which is a tiny province, so we're not going to concern ourselves with this. The National Council of Provinces must come together and sort of speak. So the idea is communication. They must then try to negotiate with the various political parties in the Tshwane Metropolitan Municipality and say, what is going on here? Why has this municipality been dissolved? Can't we resolve the issue? Because you will remember that in Chapter 3 of the Constitution, a lot of reference is made to the fact that political decision-making, so purely political issues such as how a municipality should function, and when there's now disagreement and disharmony, those kind of political decisions should not actually be decided by our courts. In America, where they have a very strict separation of powers, those kind of issues are called the political question doctrine, and where the court says we cannot and will not deal with that issue because it's a political issue. We don't have such a strong view, because I've told you we have, and I'm going to say it again, a decolonized form of separation of powers. So the courts can be approached to deal with an issue, but it's definitely not the best or modus operandi for political parties to keep rushing to the courts to resolve issues. Political issues should be resolved politically, not least because it saves money and it shows that our democracy is vibrant enough that different views can be accommodated and consensus can be reached. And so you'll also remember, as I said last week, when it comes to extreme measures having to be taken by the president, such as the president declaring a state of national defense because the Zimbabwean army is now shooting missiles across the border into South Africa, and we're now actually in a state of war. That kind of a decision also cannot be made without the National Council of Provinces also having a say on it and having a vote, so that the provinces are aware of what is going on and can therefore decide to agree that the president is now forced to declare this state of national defense, because that will inevitably mean that our own army will have to be called up to defend our borders and to aid if necessary. So that's why you see that if it's such a serious issue, the president cannot act in isolation with only the National Assembly deciding, but the National Council of Provinces must also be involved. And that's why the National Council of Provinces must make every effort to engage constructively so that it resolves any disputes concerning how the province is actually functioning, so that the provinces operate on an equal footing with each other and in a mutually respectful relationship with the National Assembly. And so I don't even need to tell you what the limits on the powers of the National Council of Provinces are, because it is identical to the limits on the National Assembly. Absolutely verbatim identical. It's just that it replaces the wording National Assembly with National Council of Provinces. So you see that we have this mirror image of the National Assembly operating to respect the interests of the provinces. So now we come to what is actually the most important function, role, or really the creation of a national legislature. It is to pass legislation. So even this issue of passing legislation, we know that it is something that falls within the National Assembly's area of power or competence. But precisely because we have a multi-sphere system of government, as I've already explained, where we have national, provincial, and local spheres, legislation must only be passed when the provinces have actually been able to make input into that legislation. Otherwise, it looks as though the national level is imposing itself on the provinces and it doesn't care about the interests of the provinces. Therefore, we have to assume at all times that when legislation is passed, that the interests of the provinces have actually been taken into account. But now comes the slightly tricky part. So right at the back of the Constitution, so you know that the Constitution starts with a preamble, then we have section 1, 2, and up to section 240 odd. Now, where am I? 200 and, now, yes, 230, where am I? 43, 243 sections of the Constitution. You cannot forget or ignore those parts of the Constitution that come after the individual sections, and those are the schedules. Schedule 1 of the Constitution tells us what our national flag looks like and what the colors represent. Schedule 1A is extremely important on this particular point about the relationship between the national and the provincial spheres, because it is Schedule 1A that tells us that we have 9 separate yet interdependent provinces. Then, I've already mentioned this before, Schedule 2 of the Constitution is of crucial importance because it is the schedule that the president is bound by, that judges are bound by, that ministers are bound by, because it is the schedule which says when the president is inaugurated, or when a minister is appointed, or when judges are appointed, they have to swear on oath that they will solemnly and without any hesitation or reservation uphold the Constitution and the law and act expressly and entirely consistent with the Constitution at all times. So you'll see then it goes on and on about the particular oaths that the president has to take and that the ministers have to take and that judges have to take. And I keep referring here also to judges in this context because of the saga of the impending impeachment of Judge John Hlophe, where he, as a judge, also said, I hereby undertake and solemnly declare that I will maintain the independence and integrity of the judiciary. And yet what apparently happened in April 2008 is that he unduly tried to interfere in the independence of the Constitutional Court by trying to apparently persuade certain judges about how they should decide a particular matter against Jacob Zuma. So I'm going through the schedules because you'll see then that Schedule 4 and 5 are absolutely vital to our discussion. But I can't ignore, obviously, Schedule 3, because that's the schedule that deals with our election processes and procedures. And we now know that it is going to have to be slightly amended to allow for an independent candidate. But remember that the Constitution generally only provides a broad outline and framework, and individual legislation like the Electoral Act is where those finer details are discussed. So now it brings us to the point on competence to pass legislation. So we have this idea, obviously, that we have elected members of Parliament or members of our provincial legislatures to pass laws on our behalf because we are busy individuals. We can't all be either in Parliament at the national sphere or in a provincial legislature. So we've vested those particular elected individuals with powers to act on our behalf. And so it now becomes important to understand when the National Assembly can make legislation without too much reference to the provinces, or when the provinces can make laws for themselves without actually having to engage the National Assembly. And that distinction is found in Schedule 4 and Schedule 5 of the Constitution. So I know it's a lot to take in, and we certainly don't expect you to know every single one of the sub points on competence. But if I were to read Schedule 4 to you, if you don't have a copy of the Constitution in front of you, Schedule 4 is the part of the Constitution that confers concurrent national and provincial legislative competence. So that very word concurrent means equal. So when it comes to a Schedule 4 issue, both the national and the provincial legislature independently. So we don't mean that they have to do it at the same time. And that's why there's a whole conflict resolution mechanism in place. But the national legislature and the provincial legislature can make their own laws on administration of indigenous forests, for example, airports, other than international and national airports, casinos, cultural matters, education at all levels, excluding tertiary education, environment, language, media, pollution, property transfer fees, public transport, trade, tourism, welfare. So you see, it's a very wide list, and that was really just a short summary of them. So there's a wide ambit within which the National Assembly can pass a law dealing, for example, with education. And that's why we have the South African Schools Act. But equally, provinces might think to themselves, we as a province want to regulate education at primary and secondary level, and the Constitution allows us to do this, so we're going to do it. Our Gauteng provincial legislature is going to pass a law that says, something like, we will permit a situation where every school-going individual or learner, as they're termed, does not have to wear a school uniform, for example. Now, that provincial law dealing with a school uniform is not really all that significant in the grand scheme of things. So the national legislation, which says, for example, that provinces can regulate certain matters about schools that they deem fit. If there is then no conflict between the general terms or the uniform provisions in the national legislation, then the provincial legislation on school uniforms is perfectly valid. And Gauteng might then say, in our province, we don't expect our learners to wear school uniforms because they are too expensive, and there's a monopoly by certain individuals on school uniforms. So we're going to say children can come to school wearing whatever they want because it might cost the parents less, for example. And the national government might then leave it alone and say there's absolutely no problem. It doesn't actually contradict any one of the uniform rules in the National South African Schools Act. If, however, suddenly the province decides that they're going to pass a law that says that certain schools can be Afrikaans only, for example, then a conflict will inevitably arise, because the South African Schools Act is clear that when it comes to schools across the country, the idea is that the school should, as far as possible, promote all official languages and therefore should not allow a school to function exclusively as an Afrikaans-speaking medium school or a Zulu school. And if then there's this conflict between what the National South African Schools Act says and the Gauteng provincial legislation on schools that says we are going to allow Afrikaans-only schools, for example, then in order to resolve the conflict, you have to go and read section 146 of the Constitution. So try to remember that, and it is on the diagram that I've drawn for you, where we sort of indicate if it's a Schedule 4 issue and there's a conflict, that conflict is resolved by resorting to the wording in section 146 of the Constitution. And therefore, when you read the beginning, it's right in the beginning of section 146, it will tell you that in a situation where there is an existing national law, so the South African Schools Act, and that existing national legislation, sorry, I might watch, it keeps doing that to me. If there's a national law that applies uniformly across the entire country and is deemed to be effective as it is, so the national law is not problematic, and that the national law has already provided norms and standards, so minimum norms and standards, and a framework and a national policy. In other words, the policy of the state shall be that there will not be any distinction based on language in schools. If we see then that section 146 is telling us that there is already a national law in place that works well across the whole country, and now it's only this particular provincial law that is problematic, then the sort of automatic resolution is that the national law must prevail over the provincial law unless it can be particularly proven that the provincial law was passed for a specific purpose, such as to maintain economic unity or to maintain national security. But in most instances in the South African legal context, we already have national laws that apply uniformly across the province. And therefore, the onus is on the provincial legislature to make sure that it is aware of the national law and therefore not waste time and effort in trying to formulate a new law that is going to ultimately be found to contradict the national law, because then the national law will prevail and that provincial law will be held in abeyance. In other words, it can't operate. So that would be a complete waste of time. However, if the provincial law is actually one that advances the right to education in a particular way, for example, by trying to improve the standards of teaching and saying that in Gauteng, In order for a teacher to be appointed, the teacher must have obtained distinctions for the majority of their subjects that they took during their education degree. If it's a law like that, that is not actually a violation of the national norms, but is promoting the national norms and making them even better, then that provincial law can prevail. So that's where it becomes a very important process of you carefully considering what is the actual nature of the law passed by the province and what is the nature of the existing national law. Can the two be reconciled? If they can be reconciled, then of course the provincial law can prevail. In other words, can survive and become operative and be implemented. If the provincial law is absolutely unconstitutional, then it cannot operate. It will just fall away. So that's the method of conflict resolution in a Schedule 4 issue. Schedule 5 is different in that Schedule 5 of the Constitution doesn't only deal with issues that are concurrent, but it tries to show us that each province has a specific geographical interest and matters of interest that apply exclusively to them. And so our Constitution tries to show, and this is one of the characteristics of a constitutional state, the Constitution tries to illustrate decentralization. So it says to provinces, you are actually allowed to make your own laws. There are certain issues that you and you alone can make laws on. So those are functional areas of exclusive provincial competence, but you will notice then that they are very limited. So they deal with what I would say in the most part are relatively uncontroversial issues like abattoirs, ambulance services, but then I realized the ambulance services is probably quite contentious because everyone's complaining that provinces don't have enough ambulances. But in any event, things like libraries, each province is deemed to have sufficient power to regulate its own libraries, such as where the library will be, what the operating hours will be, that kind of thing. Whether they will rely exclusively on national government for funding of the library or whether they will try to seek non-governmental organizational assistance to stock the library with appropriate books for the people in the province. Things like provincial planning obviously also is a matter of exclusive provincial competence. So the province, and again, now we're talking about things that are actually contentious. So the province of Gauteng before 2013, it started actually, they believed that they were taking in hand a matter of provincial planning by creating gantries that would record the number plates of motor vehicles traveling on the highways in Gauteng so that they would raise an income that way in order to maintain the road infrastructure. And so and it was then obviously adopted in December 2013 and became operative, and there's been much contestation. But now ultimately, it appears as though the will of the people who've been complaining relentlessly is going to prevail, and that the national government, or the National Minister of Transport, to be specific, has had to intervene and engage in negotiations and discussions, and there's now talk of finally eradicating e-tolls in Gauteng. So you see, the point I'm making is that there are certain issues which are deemed to be best dealt with by the provinces. And for the most part, you would think that they wouldn't cause issues. So provincial sport, for example, veterinary services, let each province deal with that themselves. However, the problem with that is that there sometimes is a serious miscommunication between what the national laws and policies are on an issue and what the province wants to do. So the e-tolls is an excellent example where the national sphere of government already has laws in place governing national highways, and that there are certain tolls in certain areas to raise funds to make sure that the roads are maintained. And because the Gauteng provincial government was then deemed to be too far removed from this center of political power and tried to make laws that only impacted on Gauteng and and I use the word ostensibly again. So for all intents and purposes, trying to be for the benefit of Gauteng. In fact, that law on e-tolls seemingly contradicts the national law and is vehemently opposed by the majority of people in Gauteng. And so therefore, the Gauteng provincial legislature was seen to be ill-equipped to deal with the issue of e-tolls because they didn't properly allow participation of the people who had particular expertise in making this decision. And therefore, the National Council of Provinces wasn't properly engaged and involved in that decision-making that took place, and therefore it is possible for that law, the Schedule 5 law, also to be declared invalid. But before I talk about the relevant provision that you refer to declare it invalid, the point that needs to be made is that you will also notice that both Schedule 4 and Schedule 5 have a Part A and a Part B. So where you see Part B, that in Schedule 5 actually refers to the municipalities, because that then is the epitome of showing that the local spheres of government have independent powers, original powers granted to them by the Constitution, and they therefore can make their own laws on particular issues, because the municipal area knows what is best for its people. You might have come across the concept of subsidiarity. Subsidiarity, one of its meanings is let the decision-making power closest to the people have ultimate say. And that's why you will see in Part B of Schedule 5 that things like beaches are dealt with by the municipality involved, mostly because not all provinces have beaches. So there's no need to say that each municipality in each province must deal with beaches, because that's completely redundant if a province doesn't have a beach. Importantly, though, it is the municipalities that must be able to deal with things like cemeteries and funeral parlors, with cleansing. Now, this is extremely important. I've mentioned this before. You cannot expect the president sitting in Tshwane or sitting in Parliament in Cape Town, for example, to be deciding on which days refuse will be removed in a particular town. So logically, it's something that needs to be dealt with by the municipality itself. Equally, things like control of public nuisances. So what would constitute a nuisance? How much noise is actually a nuisance? And that then becomes an issue of the metropolitan police, who will be told, come out and decide if this is actually a public nuisance. And if it does constitute a public nuisance, then please can you assist us and have the public nuisance brought to an immediate halt. Likewise, things like municipal parks. Well, yes, refuse removal I've already dealt with. Traffic and parking and general public places or municipal roads. Logically, those are the issues that need to be dealt with at the local sphere, because the local sphere knows what is best for its people, and it has therefore the mandate to draft what are called bylaws for the people. And so, as I said, when it's a Schedule 4 conflict and you now need to resolve the conflict, Section 146 is where you go to. When it comes to other conflicts, and other conflicts is a situation like Schedule 5, where there is an exclusive power given to a province, and yet somehow this law that is passed by the province or the bylaw passed by the municipality is inconsistent with a national law, then you revert to Section 147, because Section 147 deals with all other conflicts, and then maintains that in such an instance where there is a conflict, a clear and apparent conflict, then the national legislation will prevail. So if a really strange law has been passed by a municipality, and I think this is one of the really horrible activity questions in your study guide, but it's just to really drill home the point. If a municipality decides that it doesn't have money to remove refuse every week, but will do it only every month, that is most certainly something that is an egregious violation of any national policy or national law, and therefore the national law will have to prevail. So you can also then draw your arguments for why the national law should prevail from Section 146, because Section 146 does elaborate in a lot more depth about precisely when the national legislation must prevail. And that is in the context then of refuse removal, where the issue becomes the protection of the environment, because you can only imagine if refuse is not removed weekly but only monthly, pollution is going to become a matter of such serious consequence that immediate measures must be taken. So before things get out of hand, the national legislation should then prevail in order to rectify what is seen to be a completely unconstitutional exercise of power by the province or the municipal power. Okay, and I must say why we don't have to deal with this in too much depth here is because this is actually the entire substance of chapter 8 of the textbook that we're going to come to. So I'm trying, I know I talk a lot, but I'm trying to be brief. So now we come to the point of that I alluded to earlier. While we know that ultimately we have a provincial legislature to pass laws, there are rules in place determining the particular type of law. And remember that a law, before it is enacted, is only called a bill. So the correct terminology is a bill. So to differentiate between the different types of bills, what we have in our Constitution is the process, and this is all in terms of section 70 and onwards of the Constitution, tagging. So the very word tagging means that you are in, or that the legislature involved, and it's invariably the provincial legislature that we are referring to here in this context, they must look at the bill and be able to tag it in a particular way, because that determines the process through which it will become a law. And so the rule that has now been developed since the precedent set in the Tongoane matter is that the way in which we determine how to tag a bill is we use the substantial measure test. In other words, does this bill in substantial measure fall within a functional area that is exclusive to the province, or even though it might have concurrent competence with the national level, is it something that would be more appropriately dealt with in the provincial sphere? So we look here for the actual substance of the bill, so its content. So that's why we use the term substantial measure. And that, I don't want to go into too much depth right now, but you have to differentiate between the substantial measure test and the pith and substance. So we'll come to pith and substance later. I don't want to confuse matters. When it comes to tagging a bill, what has to be asked is, does this bill fall within a functional area that the province should actually be regulating? And so the first method of tagging that we find in section 74 is when any bill is going to be dealing with the amendment of the Constitution. Immediately, when it deals with amending of the Constitution, you must remember that the provinces have no inherent power to do anything in relation to the amendment of the Constitution. That means, so what I'm indicating here is that the bill must then be tagged as a section 74 bill, because section 74 clearly and unambiguously states that when it comes to amending the Constitution, the primary decision maker and actor is the National Assembly. And therefore, the National Council of Provinces must sort of take a step back and say, we know, therefore, that we cannot start deliberating or debating this bill at this stage. We need to leave it to the National Assembly for the National Assembly to first take a vote in order for this bill to become a law. And that's why we see that if it is a bill that's going to amend the Constitution, what you have to look for in addition is which particular provision of the Constitution is going to be changed. Because there are different thresholds or special majorities that have to be obtained. Simply put, when it comes to an amendment of Section 1, because Section 1 is the founding provisions of our Constitution, then a very high majority of 75% of the vote must be in favor of such amendment, and only thereafter, once the National Assembly has voted by an overwhelming majority of 75%, only then will that bill ever reach the National Council of Provinces, because if 75% hasn't been obtained, the whole bill falls apart. It becomes null and void. And so only once 75% of the National Assembly have voted in favor of changing Section 1, because as I've said before, Section 1 is that provision that tells us that South Africa is a free, independent, sovereign, democratic state founded on equality, dignity, freedom, and that the Constitution is supreme, that we will be predicated on the rule of law, that we will be a democracy, that we will have multi-party elections based on universal adult suffrage, and that we will have regular, free, fair elections, and that we will be an open, accountable, responsive, and democratic government. So I can't emphasize enough how important those provisions are, and precisely because of their importance is why such a high threshold has to be met in order for an amendment to take place. And just like, I think this is the example I usually use, to get 75% in a constitutional law exam is possible, but it's not easy. And that's what your thinking should be, is that it's possible to change Section 1 if there is an overwhelming majority and 75% of the National Assembly vote in favor. But it is certainly not easy, and therefore, in the majority of instances, and I would say in all instances in the country that we are and that we have designed, there will never be an instance where 75% of the National Assembly will vote to change Section 1 of the Constitution. But in addition then, as I've said, if in the unforeseen event that the National Assembly does vote by a 75% majority to change any part of Section 1 of the Constitution, only then can the bill be referred to the National Council of Provinces, and then also a high threshold of 6 out of the 9 provinces must vote in favor. That's also a high threshold, because it's not likely that you're going to get 6 provinces who are in favor of changing those foundational values and provisions of our constitution. So that's the most difficult threshold to overcome. But there are other bills amending the constitution that must also be tagged as Section 74 bills. The expropriation of land without compensation bill is a perfect example here, because it is a bill intending to amend a right in the Bill of Rights, and that right is Section 25. And in order for that to prevail or to occur, 2/3, in other words, 66.6% of the National Assembly must vote in favor of that bill. Again, 66.6% is quite difficult to obtain when the majority political party only has about, I think, 58%. I can't remember exactly. So it alone doesn't have enough votes. It would rely on other political parties to support it in that vote. But in addition, if it does succeed in getting 66.6% of the vote to amend Section 25 of the Constitution, then again, the National Council of Provinces must have its own vote, where a majority of 6 out of the 9 provincial delegations must vote in favor of that amendment. So that shows us that when it comes to changing those absolutely important provisions of the Constitution that were put there to ensure that we never ever have a repetition of our egregious colonial and apartheid past, there are high thresholds to avoid arbitrary changes to the law. But it's also possible for there to be a legitimate reason to change some other provision of the Constitution. And that's why you will have noticed, probably if you have a copy of the Constitution, that we currently have had 18 different amendments to the Constitution. The 17th Amendment, for example, dealt with the fact that our constitutional court is now the apex court. Because from the beginning of our constitutional dispensation, there was always a little bit of ambiguity where we knew that in general matters, the Supreme Court of Appeal was the highest court. But in constitutional matters, the Constitutional Court was the highest court. And so the 17th Amendment to the Constitution changed that by stating that we now have a situation where the apex court is the Constitutional Court, and that the Constitutional Court has the discretion to decide whether or not it wishes to deal with a particular case, or whether it will allow the Supreme Court of Appeal to deal with that case instead. Because what the Constitutional Court needs to consider is this an issue of particular public importance and is something that is integral to our interpretation and understanding of the Constitution? If the Constitutional Court says, yes, this is that kind of a matter, then even though it might be a matter that looks like a purely contract case, where you would think, why would the Constitutional Court want to be involved? If there's a constitutional issue at stake, then the Constitutional Court can say, we are going to be the final deciders of this case. So the the point I'm making is that there are many instances where the Constitution can be amended and where the provinces themselves are not actually required to vote. If, for example, the matter deals with something that has absolutely nothing to do with a province. However, the minimum threshold to amend the Constitution on any other matter that is going to have constitutional impact will require that the National Council of Provinces does vote, and that the minimum threshold is inevitably going to be 6 out of the 9 provinces voting in favor. Otherwise, it's just not good enough. And so those instances will be where, for example, the composition of the National Council of Provinces is now going to be amended. That is something that relates specifically to the National Council of Provinces, and therefore the National Council of Provinces must vote on the matter. Not may or can, but must. Likewise, if the proposed bill is going to alter provincial boundaries, that is going to have an effect on the province, and therefore the National Council of Provinces, which is concerned with provincial issues, must vote for such an amendment to take place. Or if we can use the general terminology of a matter that is going to amend a provision that deals with any provincial matter, you know then logically that the province must be involved. So that can be distinguished from a Section 75 bill, and a Section 75 bill is a bill that certainly does not affect the province particularly, and we call that an ordinary bill not affecting a province. And in that instance, the bill must only be introduced by the National Assembly. So you know by now that there have been a number of changes to the way the Constitution was originally conceived, in that firstly, the Constitution originally said only a member of the majority political party can introduce a bill in Parliament. That was declared invalid. Likewise, the National Council of Provinces can introduce a bill in Parliament if the matter is such that it is something that the province is particularly concerned with. But when the matter has absolutely nothing to do with the provinces, and it, for example, let's use Constitutional Amendment 17, although that's probably not the best example, but it is a scenario where the jurisdiction of the Constitutional Court actually has nothing whatsoever to do with a province, because we now know that the Constitutional Court should deal with every single constitutional matter that comes before it, and can even deal with non-constitutional matters. And therefore, provinces are bound by the decisions of the Constitutional Court, whether they like it or not. So if it's a Section 75 bill, then the National Assembly must introduce the bill, and only once that bill has been passed with a 66.6% majority by the National Assembly can the National Council of Provinces be asked, please can you now also vote on this bill, so that we make sure that we follow the correct procedure and ensure that the provinces are aware of this bill, because the provinces may need to ultimately implement this bill. And then the bill is referred to the National Council of Provinces to vote. And that's an important point, is that when the 90 delegates of the National Council of Provinces then see this bill and have deliberated on it, every single one of them has an individual vote. So that is quite telling, that it shows real democracy in action. And so a majority of votes obviously needs to be what carries the amendment, and there must be a quorum, meaning at least 33% of the members of the National Council of Provinces must be present when this vote is taken. If it's anything less than 33%, it's null and void and invalid. Yeah, so that just shows you that, in fact, we can have situations where sometimes the Section 75 bill can be passed by the National Assembly, and it doesn't even need the requisite 6 out of 9 provinces for that bill to become operative. All it actually needs is that there's a majority. And remember, a simple majority is 50% plus 1. So that's a much easier threshold. But the National Council of Provinces can then look at this bill carefully and scrutinize it and say, A, we're happy with the bill, we'll pass it. Or they can make suggested amendments to the bill, which the National Assembly then needs to consider, or they can outright reject the bill. And then there's a process in place which says that if the National Council of Provinces passes the bill without amendments, that is a straightforward process. Immediately the bill goes to the President. He appends his signature, which is known as assent, and the bill becomes law. If, however, the National Council of Provinces wants amendments to be made, then in good faith, the National Assembly must consider those proposed amendments and make the amendments if they are legitimate or valid. But the National Assembly does have the right to override those suggested amendments. So that's a little bit unfair, but it's also because the matter is not really within the purview of the province, and some provinces might just be being difficult because they are dominated by a different political party. And so in such an instance, the proposed amendments can be disregarded. If, however, the National Assembly rejects the bill outright, equally, the National Assembly can say, so what? This bill really had very little to do with you in the first place. You've considered it. We recognize that you've rejected it, but our view will prevail, and therefore we are going to send this bill to the President for him to assent to. And then it's up to the President to decide if he is happy or not, because the President might actually agree with the view of the province. But that's also an unlikely scenario. So tagging, as I've said, is then especially important when it comes to a Section 76 bill, because a Section 76 of the Constitution bill is one that relates specifically to the province and is one that is dealing with an issue that is specifically enumerated in Schedule 4 of the Constitution. So then it will be tagged as a Section 76 bill, and therefore a bill on such a matter has to be tagged as falling within the substantial measure of the functional competence of the province and the province has the first opportunity to therefore deliberate, debate, and vote on that bill and pass it. And once they are happy with it and they pass it, then they refer it to the National Assembly, because they get the first bite at the cherry, if you will. And then again, we see the scenario reversed, where even though the National Council of Provinces has decided that this bill must be passed and they've voted on it and a majority have voted in favor of the bill, because it is a Schedule 4 issue that falls within the functional competence of both. Remember the concurrent, that's the correct terminology, concurrent competence of the national and provincial sphere, then the National Assembly also has to have an opportunity to carefully scrutinize the bill. And just like we saw in a Section 75 bill, when it comes to a Section 76 bill, the National Assembly also can either unanimously accept the bill and say we're voting in favor of it, we're happy with it, we're going to send it on to the president, or they can suggest amendments, and the National Council of Provinces must, even though it's really an issue that is within the true competence of the province, they need to think about the suggested amendment and only reject the amendment if they've got legitimate grounds. And otherwise, if the National Assembly rejects it, then the bill must be referred back to the National Council of Provinces for them to consider it. And if the National Council of Provinces is still adamant that this bill needs to be passed, they can refer it to the Mediation Committee. And it's the Mediation Committee that then really has the final say. And the Mediation Committee can either make different amendments or can say, okay, no, those amendments suggested by the National Assembly are valid and logical, and therefore we find, and it's a binding decision really, we find that the bill must include those suggested amendments, and then the National Council of Provinces has no longer got much of a say because the matter has been thoroughly deliberated upon. And once the Mediation Committee makes a final decision, then everyone is bound by it, and therefore the bill in its new form, so with the amendment included, is sent to the president for his assent. And so I also keep mentioning, and in fact, we're coming to our diagram on this matter soon, but remember that even after the National Assembly and the National Council of Provinces have overwhelmingly voted in favor of a bill and they want it to become a law, the president still has the right to say, I am not satisfied with this bill. I'm sending it back to the legislature, so either to the National Assembly or the National Council of Provinces, for them to reconsider particular provisions. So the president has to be specific about which provisions he has reservations about. And then that National Assembly or National Council of Provinces must carefully consider the president's reservations and incorporate them. And if they are of the belief that the president is absolutely ill-informed and badly advised and that those amendments are not necessary, they can send the bill back to the president and say, sorry, we've not taken your suggested amendments into account. And that is still not the end of the process, because the president still has the right then to refer that bill to the Constitutional Court and to ask the Constitutional Court, please consider Section 7 That is the provision I have reservations about. Please tell me, well, make a decision on the constitutionality of Section 7. If then the Constitutional Court says there is nothing wrong with Section 7, the President has no longer got any options available to him. He has to assent to the bill. So now the fourth and final tagging that is of relevance to our discussion tonight is when it comes to money bills. So these are in terms of Section 77, and because they deal with money that is actually within the specific purview of national government, because they deal with taxes, duties, customs charges, surcharges, and which have any relevance to raising funds for the state, then this is a Section 77 bill, and it can only be introduced by the Minister of Finance, and he can only introduce it in the National Assembly. And again, because it is of such extreme importance, because it's now going to deal with whether the country has enough money to pay for vaccines against COVID, or to pay for fee-free higher education, or for housing, or for healthcare in any other respect, or for education in any other respect, etc., then it has to be dealt with according to special procedures if it needs to be amended, because there is if there's a current money bill that is, or a money act, and now this bill seeks to amend the current way of doing things, then there have to be special procedures and special majorities to ensure that the matter has been thoroughly deliberated upon, and this is not an arbitrary change to the law that might have detrimental and unintended consequences on the governance of the state. So therefore, experts have to draft the bill, and it needs to be passed by an overwhelming majority by the National Assembly. Otherwise, it is not going to work. So I've already discussed the Mediation Committee. In fact, I'm not going to spend too much time there, just roughly to say that you can tell that the Mediation Committee is also designed to be democratic in nature, and that's why it contains 9 members from the National Assembly and 9 members from the National Council of Provinces, so that there's deemed to be equality. And this Mediation Committee must make sure that the interests of all 400 members of Parliament, as well as the interests of all 9 provinces, are fully taken into account. And that's why, as I've set out, the options available to the Mediation Committee is that the Mediation Committee can support the bill and say to the National Council of Provinces, sorry for you, the bill is being passed as it is, or it can approve the suggested amendments, or it can make its own amendments. And as you see, finally, that if the Mediation Committee cannot agree and 30 days passes without agreement being reached, that bill lapses. So in order for it to be revived, it would have to be reintroduced, and probably in a new format with some changes. Otherwise, there's going to be a repeat of this process where the bill it lapses and becomes of absolutely no consequence. So here's my diagram, this diagram is in tutorial letter 102. And you've seen it before. I've tried to use it in previous PowerPoints, what you will see that I have done is numbered the processes by which a law is enacted. Now, in the past, we will have asked questions in an exam, such as, list the 10 steps by which law is passed. And it's obviously not an easy question when you have to have studied it off by heart along with everything else. But now that we have open book exams because they are online, we're not going to ask such a straightforward question. But I want you to realize that even though the minute I say national legislature, your head should start thinking that means the National Assembly or the National Council of Provinces is the one that's going to introduce the idea of this new law. And the idea of the new law is what we call policy, because it's usually after a process of engagement with stakeholders that there will be an idea or an understanding that something needs to be done to rectify a situation. And we call that then policy formulation. In other words, this is what we intend to do. And so policy is formulated not by the legislature, but in fact by the minister, so the head of the executive, who is responsible for that particular area of jurisdiction, or through internal party discussions. So you might find that the ANC will have a national elective conference and it will decide, like we've seen in the past, that it will change the Police Act and the National Prosecuting Authority Act so that we have a new crime fighting institution, no longer called the Scorpions, now called the Hawks, and they will then formulate this policy by writing it down, but in the form of what is actually just a working document, because we call it a green paper, because really all it is sort of an essay where it says, an introduction about this is what we intend to do, and then the main part is this is how we intend to do it, and therefore we propose to pass a law that is going to do X, Y, and Z. The green paper is what needs to be looked at by the public. But remember, as I've said, our parliament has to function openly, transparently. So that green paper, even though it's actually drafted by the executive and the state law advisors who assist the executive to do their work, it is part of the legislative process. And that's why the green paper will be published in the Government Gazette, and then there will be notifications sent out saying there's this policy in place. Please, can you comment? And then after there's been a process of public comment, that green paper is revised based on the public feedback, and it is then transformed to what we call a white paper. And the white paper is then very much going to illustrate what the new law will look like. And again, because the public cannot be left out of the process, they need to be able to engage on this proposed legislation. So only once there've been at least 2 separate stages through which the public at large can engage in the bill or in the proposed bill, will the bill actually be drafted. And that bill will have an explanation saying, this is the reason why we've drafted the bill. This is why we think it is necessary that the bill is passed. and cabinet sitting together. So cabinet is part of the executive. Cabinet then will decide, yes, we think this is a useful and necessary bill. And so by number 5, you see that only once cabinet has approved the draft bill do the state law advisors then have to carefully scrutinize the bill and see that it is actually constitutional. And that is finally, if you now look at the left-hand side, where the minister who originally initiated this idea stands up in the National Assembly and he says, I am now introducing for deliberation the bill hereby termed the Fee-Free Education Bill, for example. And so it is now formally introduced, and that's when the whole process actually begins of how the National Assembly all get an opportunity to read the bill, read the explanatory memorandum. If they wish to, go and look at the white paper to see what the views of the public were. And that is what we call the first reading, because everyone then is supposed to carefully apply, everyone being the 400 members of Parliament, carefully apply their mind to the matter. Or if the bill was initiated by a NEC, so I'm now talking about the provincial sphere. So a member of the executive committee, so that's the equivalent of a minister, but at the provincial sphere, then it can be introduced in the National Council of Provinces. So that's why I have National Council of Provinces in brackets at number 6. And I've not said it because I'm trying to let us get through this as fast as we can, but you will see on the right-hand side of the page, in fact, I am quickly going to go up, that none of this process of number 1, 2, 3, 4, 5, and 6 happens without the judiciary being able to be asked to actually declare the law or the process that is being followed so far unconstitutional. Or, like I've mentioned repeatedly, if the green paper and the white paper have been drafted and there has been absolutely no public participation, it must be declared invalid. That's what the Doctors for Life case and the Matatiele municipality case have taught us. So that's the sort of general principle. The Merafong case taught us that the least that we can expect is that reasonable steps were taken to facilitate public involvement. And so equally, at the first reading of the bill, the National Assembly is not at that stage going to vote. But if at that moment it becomes clear that there is a groundswell of enthusiasm for the new legislation, it's still possible for someone to go to court. And that's why in the example I used of the ANC taking a decision to disband the Scorpions and create the Hawks through amending the Police Act and amending the National Prosecuting Authority Act, that is when Hugh Glenister in 2009 did go to the Constitutional Court and say, please stop this from happening before it's too late. And you will see what I wrote there, that the Constitutional Court said, sorry, we respect the integrity of the legislature. The legislature has its opportunity to fully discuss the bill. And only if the legislature has finished deliberating and has voted in favor of the bill, and you still are convinced that it is unconstitutional, then you can come back to us. But at this stage, we are not convinced that it's necessary for us to intervene, because we do not see at this stage irreversible or irremedial harm. And so then the seventh step is that the portfolio committee that is dedicated to dealing with higher education, for example, those members who have a particular interest and expertise in education issues, will be the ones who review this bill and again ask the public to be involved as far as possible and suggest other methods in which to implement the proposed law or to make other suggestions. And then finally, you see that even after the National Assembly has passed the bill without any reservations and it's a majority vote, the National Council of Provinces still needs to vote on it. And that's where at number 9, if the bill was approved without any reservations or rejections and suggested amendments by the National Council of Provinces, then the National Assembly will and does send the bill to the president and say, please sign this bill, and then it becomes legislation. And so actually what I have already discussed is what you see here in 10 and 11, is that even once both houses of parliament have passed the bill and it's given to the president, you will see here at number 11 and 12 and 13, I suppose, and 14, it's everything I've already said to you, which is that the president is still allowed to say, hang on, I have reservations. So reservations you see in number 12, and you see then the relationship with the judiciary where the court, well, rather after the president has sent the bill back to the National Assembly or the National Council of Provinces, and they've sent it back to him and said, there's nothing wrong with it, sign it, he can send it to the court. We've seen it in the ex parte President of the Republic case, where the court did look at the bill after the president had referred it to them, and the court said, what must we actually, or what can we do? In other words, do we only consider the reservations that the president has? And they said, yes. Let's restrict ourselves to only what the president is concerned about. Otherwise, we are actually intruding into the domain of the legislature and the executive. And they said, therefore, all they need to do is look at the particular provision and decide, is it constitutional or not? If it's not constitutional, then they can say to the legislature, sorry, we do agree with the president. This bill is problematic because there are these unforeseen eventualities. Please, can you change the bill? And that's when you see it can be referred back to the National Assembly at number 14, and then the National Assembly has to amend the bill and vote again in order to pass the bill. And then the president is again asked to sign the bill and make it become operative. And at that stage, the president has used up all his opportunities and he has no choice but to sign the bill. I'm actually not even going to discuss the next part here about why it is that legislation is usually initiated by the cabinet member, because it's actually quite logical in that cabinet member was appointed by the president to be a member of cabinet in the portfolio of health or education or social welfare. So they know what's best. They are supposed to know what the current law says, know what's happening on the ground, because they're communicating with the provinces and with the local people, and respond responding to the service delivery protests, for example, and therefore drawing up a new law because they see that the people who are protesting have valid concerns. So really it's because of our party political system where that person has been put there by the president to actually make sure that all issues relating to that broad area of jurisdiction must be as best as possible. And that's why we see a minister invariably initiating legislation. And there is absolutely no need for me to repeat the Doctors for Life case information that you see here on page 17, because I've said it repeatedly, that we have this multi-sphere system of government, which is interdependent, integrated, interrelated, communicates with each other, and where the views of the people must prevail, that the people cannot be left out of decision-making, because such process would be fatally flawed and the law would be absolutely not acceptable. So the very last point here is just that Parliament has a positive duty to provide meaningful opportunities for public participation, and what needs to be proven is that Parliament, and I'm including in the National Council of Provinces, must have been reasonable, that they genuinely requested feedback and participation from the people. And so I've already mentioned here that lobbying by organized groups, lobbying meaning bringing a petition, lobbying the people, saying we are going to go on strike, let's draft this petition demanding a change to the law. That is all part of the democratic process. And if this lobbying has happened and a petition has been given to the minister about higher education, the minister must act on it in good faith. And the very last point there is just the public hearings are to make sure that anyone who has an interest and expertise in a particular matter can bring that information to Parliament, because we know that Parliament doesn't necessarily know everything. And so I've already mentioned Matatiel case, I've mentioned Merafong, Mutse Demarcation Forum, I think we discussed it last week. There are numerous cases where the courts have said public participation is essential. Now, this very, very last bit, I'm going to leave for next week because it's an important part and it feeds directly into our discussion on chapter 5, because I can see it's now 8:45 and we're all tired, and because we have discussed it before, but it shows you the Executive Council challenging the president in his capacity as head of the executive. So this issue that came up in this case is actually an executive issue. So let us leave it to next week and discuss it when we discuss the executive. Okay, so after that very long lecture, are there questions? Alice, your hand is up. And it's probably been for a long time. Sorry. Alice, do you have a question?
Yes, Professor, I have a question. I hope you're doing well.
Yes, thank you.
My question is, I'm concerned about the issue of Minister of Health, Zweli Mkhize. Why can't, because he might be implicated in certain cases, why can't a deputy minister take his position as a Minister of Health in his case? Why can't he do that? Because apparently the president said he will rather take someone in a ministerial portfolio somewhere other than taking his deputy. So why do we have deputy ministers if in a case where we want them to step in, they cannot step in? Thank you.
Well, that is a fantastic question, because I know that it has been discussed at length recently, because there is no actual answer. In some countries, the deputy minister is there because they have specific expertise in the area, and they are actually there to support and complement the minister and step in when the minister is unavailable. For some, our constitution is absolutely silent on the role of deputy ministers. And of course, there's been this criticism that Cyril Ramaphosa said he's going to be cutting down the cost of our executive by doing away with deputy ministers, because they actually are not needed, because we already have directors general who are those who are, you know, intricately involved in the workings of that department and could step into the place of the minister. So there is no correct answer to your question. All we do know is that because the deputy minister has no original constitutional power to act as a minister, because they're only a deputy minister, when a minister is ill or incapacitated or has to step down, like we've seen, another minister has to act in their place. So there is no proper answer, except that the fact that our deputy ministers were not ever in the constitution granted real, tangible powers.
It's so sad, Professor, because our country now, it's in a position where in this portfolio we are in need of. We need the expertise, and we need a leader who can really. I feel it's unconstitutional for our president to, for that. But thank you for the answer. I understand.
No, look, I think the president had to choose who he thought was the next best possible alternative.
But we choose someone from another portfolio. Yeah. No, I understand. Thank you so much.
He was constrained. The president himself was constrained by the constitution. What the president should probably do is, like we've seen, like this discussion we had tonight, even though we know that there's a presumption of innocence until proven guilty, Zweli Mkhize should probably be removed as president, as a minister, so that there can be a legitimate cabinet reshuffle and someone with expertise can be then placed in the position of the incumbent Minister of Health, because they have the expertise. I mean, it could even be, you remember also, now I'm speaking very hypothetically, that two ministers can be non-members of the National Assembly. Someone like Salim Abdul Karim could become the Minister of Health if he has been part of the decision-making process throughout, and he seems to have all the expertise and knowledge and was advising the Minister of Health. So really, the president should be more proactive. I mean, I don't want to be funny, but he was more concerned with going to England to the G7 summit than actually sort of probably sticking around for a few more hours and saying, I am now shuffling cabinet to make sure that we are not compromised by this. So that's a long answer to your question. Are there any other questions or comments? Or I know it's a very long lecture we've just had. Well, are you okay for tonight? So next week we should do chapter 5. I would like us hopefully maybe to even do chapter 7 next week, because chapter 7 is very short. Because thereafter you're going to go into chapter 6, which is long, and chapter 8, which is very long. So maybe we'll try and do 5 and 7 next week, if you're okay with that. And then, of course, we will have many revision classes that you will probably need closer to the exam, but I am trying to accommodate the early completion students by getting everything done before the exam that's being written on the 15th of July. All right, so are you all okay then with us leaving the lecture there? It has been recorded. Thank you for participating and listening throughout, and see you next week then, 6 o'clock. All right, thank you.
Thank you,
Thanks.
Professor.
Bye-bye.
Thank you.
Bye-bye.
Good night.
Bye.